Good afternoon. Welcome to all of you, to all of our community of students and staff and faculty and alums and members of the public who are interested in the decision issued last Friday in Dobbs v. Women's Health Organization. In overturning Roe v. Wade, Dobbs held that the Constitution does not protect abortion rights. We are here today to discuss that opinion. In doing so, this law school continues its tradition of educating our students and the public to further understanding and analysis of the law. In doing so, the faculty we've gathered here will provide expert insights and opinion on these important legal developments. As an educational institution, our first and best function is to educate, and that is what we're here to do today. At the same time, I want to recognize that the opinion will have effects on our students. And for the students on this webinar today, I want to also remind you that the law school's Office of Student Affairs is positioned to assist all our students. The office is prepared to connect you to counseling services and is in the process of working with the campus Office of Student Counseling to create an embedded, or to bring in an embedded counselor into the law school starting this fall. The Fromm Office of Student Affairs has a long tradition of providing emergency assistance and financial assistance to our students who are in need, and will continue to do that as is needed. And we encourage our students to seek out assistance from our Office of Student Affairs if that is helpful. Before proceeding, I also want to thank our communications office, our technology office, and our faculty panelists for the fast action in pulling this event together and for broadcasting it broadly. We have nearly 500 people registered for this event, and we're thrilled to be able to provide this public service to all of you. Without more, let me introduce our panelists and our moderators. Our moderator will provide you with a more detailed plan for this hour-long webinar. Our panelists include Jody Madeira, who is a professor of law, and Louis F. Neiser, faculty fellow. She's the co-director of our Center for Law, Society, and Culture. Dan Conkle is our Robert H. McKinney Professor of Law, Emeritus, and he's also an adjunct professor of religious studies. Steve Sanders is a professor of law. All three of our colleagues here at the Maurer School of Law. Steve Sanders is a professor of law, an adjunct professor in the Department of Political Science, and affiliated faculty member in the Department of Gender Studies and the Kinsey Institute. Finally, our moderator, who will guide us through this session, is Deb Widiss, who's our Associate Dean for Research and Faculty Affairs, a professor of law, and Ira C. Batman Faculty Fellow. Deborah, you have the floor.
Thank you so much. And I am really glad we have the opportunity to gather as a community to talk about this opinion and what it will mean. Before turning to the panelists, we thought it would be helpful just to provide a little bit of an overview of some of the key constitutional issues in the case. Recognizing that there's a range of knowledge in the audience, from people that have read all 200 pages of the opinion and various concurrences to some people that may have never been to law school and have no familiarity with the legal issues. So just briefly, under our constitutional system, generally we defer and expect lawmaking to be done by legislative bodies, that is either at the state or federal level. But the Constitution imposes some important limitations on what laws can do, and particularly that laws can't infringe on some key personal rights. And it's a court's job, and ultimately the Supreme Court's job, to decide whether or not a law does infringe on those kind of key personal rights, and if it does, if there's a good enough justification for it. The Constitution doesn't specifically reference abortion, but it does have more general language that could be deemed to encompass abortion rights. And in Roe versus Wade, and then which was a decision from 1973, and then in the Casey decision, a 1992 decision that largely reaffirmed Roe, the court in those earlier decisions held that choices regarding abortion were implicit in a general right of privacy, or specifically within the 14th Amendment, which provides that a state cannot deprive a person of liberty without due process of law. And the court in those earlier decisions looked to precedents that had said that the right to make choices regarding use of contraception and make decisions about child rearing and marriage were fundamental rights that were within the idea of liberty, as referenced by the 14th Amendment and these other sort of privacy principles, and that therefore abortion rights implicated fundamental interests And essentially there was a balancing test, but until viability, the idea was women could generally choose to terminate a pregnancy if they wished. After viability, there was more latitude for states to impose significant restrictions on the procedure, but still with an exception for the life of the mother at least. Which brings us to the Dobbs case. So the Dobbs case was a challenge to a Mississippi law that prohibited all abortions after 15 weeks, unless they were required by a medical emergency or a severe fetal abnormality. Because that was an absolute ban prior to viability, or an almost absolute ban, it was unconstitutional under the reasoning of Roe and Casey, but the court uses Dobbs as an opportunity to revisit the constitutional reasoning from those cases and ultimately decides that they were wrongly decided. So Justice Alito, writing for 4 other justices, says that the approach that Roe and Casey took to determining whether or not a right was fundamental and within this concept of liberty was incorrect, and that the key question is whether or not it's deeply rooted in our country's history and tradition, and essential to our nation's scheme of ordered liberty. That's language that comes from earlier cases. And applying that language and looking specifically at what was the state of the law at the time that the 14th Amendment was enacted in the 1860s, the court says, well, at that point in time, abortion was generally criminalized, at least after quickening, and which is sort of when you can first feel a fetus and sort of similar to viability. And even prior to quickening, there wasn't an affirmative right to abortion. And so the court concludes it's not a fundamental right. The majority opinion by Justice Alito, however, says this holding should not be grounds to question those other liberties that had been recognized as fundamental rights, including the right to make choices around contraception, same-sex intimacy, same-sex marriage, but that abortion, at least because of the potential fetal life and concerns about that, is different from those other liberties, and that abortion is not protected. The court also rejected the idea that of stare decisis, that we should conform to prior decisions, should control here, and says Roe was wrong in our view the day it was decided, and we're not going to continue what we deem to be an incorrect decision, and points out that the court has overturned earlier decisions in other contexts, specifically referencing Brown versus Board of Education, which overturned Plessy versus Ferguson's rule of separate but equal, and the court says, like Plessy, Roe was wrong from the beginning, and we should not continue it. And so the new rule after Dobbs is that essentially a state may pass abortion regulations so long as there's a rational basis for its action, that there will be a strong presumption of validity for abortion restrictions if a state chooses to enact them, and that the legitimate state interests that could be protected include preservation of, quote, prenatal life at all stages of development, which is just signaling that if a state chooses to ban abortion even from the moment of contraception, and references the idea of preservation of prenatal life at all stages of development, that the court has said that is a legitimate interest that a state could look to protect. So that's, in a very quick summary. We'll hear more from our panelists, the majority opinion. I just wanted to briefly mention a concurrence by Justice Thomas, who agreed with the court that Roe was wrongly decided, but goes further than the court in saying that he thinks the whole concept of these kind of substantive liberties that have been recognized as protected under the 14th Amendment, that those cases are wrong in his mind, and that he believes the court in the future should reconsider all of those other ideas as well, that is choices regarding contraception, same-sex marriage, same-sex intimacy. He says he believes those cases should be reconsidered as well. Justice Kavanaugh, on the other hand, wrote a concurrence reaffirming that he does not think those liberties are jeopardized by the court's decision, and that abortion is different, and just that in his view, the Constitution is neutral on abortion, and so therefore it's up to the states. And he really emphasizes that the states can take steps to continue to permit abortions through all state, in whatever balance feels right. Very briefly, there is a dissent. Justice Roberts writes a concurrence that essentially would not have overturned Roe, but would have held that the Mississippi law was permissible. But then there's a dissent signed jointly by Justices Breyer, Sotomayor, and Kagan. And the dissent would have continued the general rule from Roe and Casey and really emphasizes the costs of repealing abortion rights on women, what it will mean for women's autonomy and choices, and emphasizing particularly that even if some states continue to permit legalized abortion, poor women in particular who may live far from those states will functionally not have access to abortion. And also that there's nothing in the court's reasoning that would preclude Congress from potentially passing a law that prohibited abortion nationwide. And further, the dissent says, we don't think that there is a limiting principle in the court's reasoning that would suggest that those other substantive liberties are also not potentially at stake. So I think with that, just trying to lay the groundwork, I'd like to then go ahead and turn to our wonderful panelists to explore more what this will mean. And starting with Professor Conkle, just practically speaking, what is this ruling going to mean for abortion rights in the country in general, and maybe particularly in Indiana?
Sure. Yeah, I think you've nicely highlighted. Basically, we have really a dramatic shift in legal doctrine from the Supreme Court's decision in 1973, which announced a very strict standard of judicial scrutiny for abortion regulations, especially prior to the point of fetal viability, which is typically 22 to 23 weeks of pregnancy, to the Casey decision of 1992, which modified Roe versus Wade and substituted a so-called undue burden standard for Roe versus Wade's strict scrutiny, but still declared that pre-viability abortion decision-making could not be completely prohibited or unduly burdened by the state. So now we come to the Dobbs case. If Roe versus Wade was perhaps the most controversial decision from the Supreme Court in the latter half of the 20th century, I would suggest that Dobbs to date is probably, and maybe certainly, the most controversial decision from the Supreme Court in the 21st century. What Dobbs does, as Professor Widiss suggested, is legally, as a constitutional matter, substitute an extremely lenient standard of judicial review, the so-called rational basis test. And I think you can find it at the end of the Supreme Court's decision. The discussion is relatively brief from the majority opinion by Justice Alito, but just to highlight what Alito says, under the rational basis test, he says, for the majority, the states may regulate abortion for legitimate reasons. Courts cannot substitute their social and economic beliefs for the judgment of legislative bodies. A law regulating abortion, like health and welfare laws generally, is entitled to a strong presumption of validity. And then he highlights some of the grounds Professor Widiss mentioned that would count as legitimate, including preservation of prenatal life at all stages of development. He adds others, protection of maternal health and safety, elimination of particularly gruesome or barbaric medical procedures, preservation of the integrity of the medical profession, mitigation of fetal pain, and the prevention of discrimination on the basis of race, sex, or disability. And in citing the rational basis test, he cites extremely deferential cases from the Supreme Court in other areas of law that broadly defer to legislative judgments on issues such as public health, safety, and morality. So what this means is that essentially legislatures have extremely broad discretion. And at issue, for example, in the state of Indiana, there will be a special legislative session called by Governor Holcomb for other reasons, beginning July 6th, in which the issue will be taken up. Legislative leaders to date have not indicated precisely what they have in mind. Under Indiana law as it currently stands, there are various abortion restrictions. there is a prohibition on abortion after 20 weeks of pregnancy, actually prior to fetal viability, with an exception if the abortion is necessary to avoid a substantial permanent impairment of the life or physical health of the woman. So the issue post-Dobbs is, to what extent will Indiana move that prohibition line forward in pregnancy? Might it adopt a 15-week period such as that at issue in the Dobbs case itself? Might it go to 6 weeks, such as currently prevails in Texas? Might it go all the way back to the point of fertilization? All of those things, I think, are rather clearly permitted if the legislature so chooses under the Supreme Court's ruling in Dobbs. In terms of potential exceptions, I assume the Indiana legislature will include an exception for the life of the woman as under existing law. Whether it will also include a broader health exception remains to be seen. I think an exception for the woman's life arguably is required constitutionally, even under the rational basis test. Other exceptions seemingly will be up to the legislature and will depend upon the judgment that the Indiana legislature makes, including, for example, exceptions for rape, exceptions for incest, exceptions if there is a serious fetal deformity, for example, such that if carried to term, the baby would have a very limited lifespan. So basically, the ball has been thrown into the legislative domain, and that's where the debate about abortion will now be taking place. So I'll leave it at that. We can come back to further, more specific questions later.
Thank you so much. And I should say, I'm just going to ask a couple of questions to kind of lay the groundwork for some of the different issues we might want to explore, but I would encourage participants to go ahead and start using the Q&A as well to submit additional questions, and we'll try to get through as many as we can. But I wanted to turn to Professor Madeira and just ask, what will this decision mean for pregnant people, including pregnant women who may not actually be seeking abortion, but are looking for other kinds of prenatal health care?
I think that's a really great question. First of all, and just to emphasize, I hope no one is under the impression that this is actually going to stop abortion. Women will still obtain procedures, but the burden will fall upon the shoulders of those who are least able to bear it. More women will become injured, become infertile, and they will die. Because before Roe was passed, 17% of maternal deaths from pregnancy and childbirth were actually from illegal abortion. It's also going to have a chilling effect upon prenatal health care. Who will go in to report a miscarriage for fear they will get in trouble? We're already hearing from clinics who are consulting with lawyers about treating women who proceed for miscarriages to seek treatment. And they don't know whether women are going in for miscarriages or for abortion care. Will doctors treat women who are miscarrying for fear that they are actually aiding in abortion if state laws in Indiana go in that direction? This will also imperil the ability of Hoosiers to obtain reproductive technology services, unless these issues are specifically addressed with and exempted in any legislation that's passed. If life begins at conception, then can embryos be frozen? Can they be genetically tested? Must all embryos be used regardless of whatever genetic conditions they may have? Arizona already passed a state law a few years back, stating that divorcing couples actually had to give embryos to the party most likely to gestate them in the event of a divorcing couple, even if a couple had agreed the embryos would be destroyed. And if abortion laws do address reproductive technology, then will they create two classes of embryos, one formed ex vivo in a laboratory, one in vivo in a uterus through spontaneous conception?
Thank you. Any of the other panelists want to add anything on that point? Or okay, then let's, I will also just add on that point, because it relates to my own research, which is one of the other challenges is that our laws in general don't provide a lot of support for pregnant women. And so we don't have basic things like a right to paid time off for new parents or new mothers, a nationwide right to accommodations if you need them in the workplace, a right to affordable childcare, or health insurance. And so there's a whole host of other challenges that will arise as well. And, I think there's a lot of looking at and trying to think about bolstering those rights. But I wanted to then turn to Professor Sanders and ask, what about those other liberties? So, we have the majority opinion with Justice Alito saying they're not imperiled by this decision and the court's reasoning, but Justice Thomas saying very clearly he thinks that they are. What's going on there?
Sure. First, I think it's important to remember the Supreme Court first announced, pardon me, something that has come to be called the constitutional right of privacy in 1965 in the Griswold decision, which said that states couldn't outlaw the use of contraceptives. Roe, then in 1973, the court located that right in the 14th Amendment's due process clause, which historically was and has continued to be the home for so-called unenumerated rights, rights that aren't specifically mentioned in the Constitution, but which the court has found worthy of protection as a matter of liberty. Not only recent things like the right of consenting adults to be free from sodomy laws, but also the right of blood relatives to live together, the right to refuse unwanted medical interventions, parental rights over children. All of those are matters of due process law. The court referred to these decisions collectively as a realm of personal liberty that protects the most intimate and personal choices that a person can make, but that language was from the Casey decision, which has now been overruled. As for the majority's reassurance that other matters of due process liberty are not affected, I think it's simply intellectually dishonest to say that other decisions aren't called into question when, like in a game of Jenga, you've invalidated a decision that provides a foundation on which the others rest and the others depend. I think it's the difference between someone who takes constitutional doctrine seriously and someone who just wants what is sometimes called a ticket good for one day, a results-oriented decision without worrying about the other consequences. Roe, the Dobbs decision didn't just invalidate Roe. It really gutted one of the court's major approaches to what's called substantive due process, this protection for unenumerated liberties. And so the belief that abortion is different because it involves what some people believe to be the taking of a life, which was the majority's position, to my mind, explains politically why abortion is different and more urgent and why conservatives want to see it denied constitutional protection. But it doesn't explain how those other decisions stand and why, when again, you've not only overruled Roe, but you have criticized, if not overruled and eviscerated, an entire approach to substantive due process. Now, it's impossible to predict the future, I think. Doctrinal consistency is usually more of concern to law professors and law students than it is to the court. I think a frontal assault on things like same-sex marriage or the protection against sodomy laws is unlikely. But I think what we will see is a lot of what I would call mischief. Chipping away at aspects of those rights. States that will now be emboldened to treat same-sex couples differently, for example, when it comes to birth certificates or parentage rights or the benefits that go along with marriage, arguing that same-sex marriage is different and the court said so, and those marriages don't have to be treated in the same way. Justice Thomas, as has been noted, expressly said he would like to see these decisions reconsidered. Interestingly, he left out decisions like the safeguard for parental rights or the right against unwanted medical care, which are protected by the same substantive due process doctrine as sodomy laws and arguably marriage. Justice Thomas has always been sort of off on his own projects. He's always been willing to be the sort of lone wolf, taking oftentimes the most extreme view. I think as a practical matter, having gone so far out of its way to say these other rights are not at issue, even this particular court majority would probably tread cautiously, would have enough shame not to mess with those things, at least in the immediate future. One point I would make about same-sex marriage, I think we've quickly settled into a conventional wisdom that the Obergefell decision from 2015 involving same-sex marriage is now at risk. The Supreme Court's marriage cases going back to Loving versus Virginia in 1965 have always been hybrids of due process and the Equal Protection Clause. The work that due process plays is to say that the right to marry is of fundamental importance to everyone. That was laid down in Loving, but then the court has always used equal protection reasoning to actually test the state's reasons for excluding a particular group from marriage, whether it was interracial couples or fathers who were behind on their child support, as in a 1970s case, or with same-sex couples. And so I'm writing an op-ed piece in which I argue that it's dangerous to fall into this idea that same-sex marriage rests on as flimsy and airy a doctrinal foundation as the right to abortion did from Roe in 1973. I actually think the right to same-sex marriage, the Obergefell case, is more predominantly an equal protection matter and an equal protection decision, and that puts it on a firmer doctrinal ground. So I'm happy to talk about other issues or elaborate more during the Q&A period.
Great. Well, we have a lot of great questions in the queue, and so I'm just going to go ahead and start pivoting to them. But one of them that builds off of Professor Sanders' last comments is the question as to why this is also not a hybrid issue that implicates equality rights, and specifically why thinking about abortion is not deemed a matter of sex discrimination. And I don't know if one of the panelists wants to address that question.
Well, what, as I recall, what the majority says, whether or not persuasively, is that relying on a case called Gootledig, that discrimination based on pregnancy doesn't count as sex-based discrimination. I think that ruling has been contested in Gootledig, but that's essentially, I think, about all the majority has to say on that point. If I might, just to respond quickly to Professor Sanders, I think in terms of the other claims of right that have been put at issue by Justice Thomas, the key, as Professor Sanders suggests, I think, is not so much Justice Thomas's concurrence, but instead the concurring opinions of Justice Kavanaugh and the opinion of Chief Justice Roberts concurring in the judgment, who Kavanaugh makes it abundantly clear that he's not inclined to go in that direction. Chief Justice Roberts implicitly says the same thing, saying stare decisis is committed to a jurisprudential judgment in the court's discretion, indicating that he would not have overruled Roe, root and branch in this case, much less, I think, go on to other precedents. The other point is that I think it is possible to conceptualize the other precedents in a way, and the court talks about this a bit, in terms of whether or not the right to choose abortion is part of a broader core historical right of privacy or autonomy. And it says pure autonomy goes too far, but it doesn't rule out, I don't think, the possibility that the court could, by conceptualizing the right a bit differently, say that family-related matters, intimacy-related matters that do not involve the destruction of potential human life are protected as a matter of what could be described as historical protection, family-related rights, broadly understood. It takes some, intellectual footwork to make that kind of a move, but I don't think it's impossible. I also don't think that as a matter of principled stare decisis, even on the majority's view, I think it's possible to distinguish something like same-sex marriage in terms of reliance interests from the court's understanding of reliance as articulated, for example, in Casey. So I'm not sure that the court, even as a matter of principle, would be entirely out of bounds if it ruled in the future that the other precedents remain intact.
Great, thank you. So we have several different questions kind of referring to state constitutions and the extent to which state constitutions might provide more robust protection of abortion rights than the court in Dobbs deems the federal constitution does. Does anyone want to sort of talk about that issue and the questions that might arise from state constitutional provisions?
The states are really free now. The whole point of the Dobbs decision is that states have complete license to be as restrictive or as accepting of abortion as they want to be. As Professor Conkle said, restrictions remain subject to a rational basis test, but that is typically fairly toothless. Theoretically, if a state wants to license abortion on demand at any point during the abortion, it's free to do so. There is no Dobbs licenses the state to do so. There's no federal constitutional prohibition on that. And so oftentimes during periods when constitutional rights were out of fashion in one way or another, both progressives and conservatives have often looked to state constitutions for greater protection of individual liberties. The only thing that could put that sort of thing at risk is the threat that Congress might pass some sort of law prohibiting abortion as a matter of federal law. The combination of the filibuster and sort of other political factors, I think, make that unlikely in the near future. Something like that could preempt state constitutions. But yes, both legislatively and in terms of their constitutions, at this point, states are free to be as generous related to reproductive freedom or as conservative and restrictive as they want to be.
There's also several questions, and this might get to how generous or restrictive states may be about religious freedom and how religious freedom principles might interplay with abortion, and particularly a challenge brought by a synagogue in Florida asserting a religious liberty interest in being able to access abortion and referencing principles under Jewish law that understand life is beginning at conception and the paramount importance in protecting the health of a pregnant mother or pregnant person. And I should say here, we've been sort of referencing women, but trans people can and do become pregnant, non-binary people, and separately, I will be posing a question sort of building on that question as well. But on the religious liberty, did someone want to weigh in?
Yeah, I can comment briefly. I mean, basically, I think that if in fact a woman claims that her religion requires her to have an abortion, or that her primary motivation is religious in character, then at least through the initial stage of the analysis, she might qualify for a religious exemption from an otherwise applicable prohibition. Any religious exemption is, I mentioned at the beginning of my initial comments, the idea of strict scrutiny. Under strict scrutiny, if in fact the Supreme Court, for example, if this got to the US Supreme Court as a federal issue, we're considering that issue, the question would be whether a state has a sufficient, even compelling interest in protecting prenatal life, even against that religious exemption. If it's a state law issue, as I think it is in Florida, the state court would be asked to decide that same question, assuming there is in essence, a substantial burden on the exercise of religion. Does the state's interest in overcoming that interest qualify as sufficiently compelling? So that's the formal analysis. I think, as a matter of legal realism, I think it is unlikely that the US Supreme Court would recognize a religious exemption claim to the extent that that might undermine its general ruling that the states should be able to deal with this issue more or less as they see fit. But it's not inconceivable in particular circumstances that a religious exemption could be recognized.
Thanks. And then pivoting to that question of access by trans people and non-binary people to reproductive health services, what implications do you think this decision will have for that population in particular?
I don't have any specific answer to that question. Maybe others do. I do think it's interesting to think about the trans issue in terms of whether or how it intersects with the idea that the right to choose abortion is a matter of women's rights. and whether the language of women's rights should continue to prevail from those who are advocating on behalf of the right to choose abortion, whether to eliminate that kind of language in favor of more inclusive language could in fact undermine what at least I think historically has been part of the core argument in favor of a woman's right to choose.
As a practical matter, in terms of the way the public understands the debate and understands constitutional law as protecting and the rights of women and remedying injustices against women, I think that's true. Although the court's equal protection, gender and sex-related cases have always really emphasized the breaking down of gender stereotypes. And so, once again, as a doctrinal matter, trans rights have benefited greatly from those cases because at their core, courts have said they're not about mistreatment of men versus women or vice versa. They're about attacking gender stereotypes, stereotype notions of what one gender or the other is capable of. In terms of Dobbs, I'm not sure, to the extent that a transgender man can get pregnant and seek reproductive health care. I'm not sure that person is in any different a place than a cisgender woman would be. They're not going to be able to get an abortion either if their state prohibits it, or they'll be subject to the same rules. But at the same time, we do also see other issues related to transgender people's access to health care being legislated and litigated.
Great, thanks. There's questions just kind of about the rationale of the court, and particularly the contrast between the language in Dobbs about the importance of returning this issue to the states and the gun rights decision that happened the day before, where New York had passed, rather restrictive gun legislation, and the court held that was not permissible. Does anybody want to weigh in on that contrast and the larger issues of federalism at play here?
I'll weigh in with the comparison to Bruin. So read together, I think we can see Bruin and Dobbs as part of a mission to rewind the ability of state legislatures to regulate certain issues in ways that basically go against the conservative ideological agenda. Bruin ends discretionary firearms permits. It states that the right to carry firearms exists outside the home, and enunciates a new test for assessing the constitutionality of firearms regulations that actually is quite similar to the test in Dobbs, based on history and tradition. If it didn't exist in 1868, that's a bad thing. Women didn't have an independent legal existence, by the way, in Indiana in 1868. That's just something I'll point out. Both render a key state concern invisible. In Bruin, what's invisible is the pervasiveness of gun violence and public safety and the state's obligation to safeguard public safety under the 10th Amendment. In Dobbs, what's invisible are largely women or individuals with a uterus who can get pregnant, let's put it that way, together with the social, relational, and economic lived experience. And both are at odds, inconsistent, and even incoherent when read together. Bruin states that courts, federal courts especially, defer too often to state legislatures. So universally, basically this deference, according to them, compels a certain result, which upholds gun regulations that they don't think deserve to be upheld. And so they posit this history and tradition test as a way to return the country to the Second Amendment. But in Dobbs, Alito faults the Roe majority for acting like a legislature and allegedly usurping the democratic process by making decisions that should be made by elected officials, and then actually does the same thing by unilaterally getting rid of the abortion right and substantive due process in the package.
Thank you. And what about conflicts between states and the reality that, women will, some and other people needing abortion services, try to travel, leaving one state where it may be illegal to go to a different state where it's legal? What will be the ambit of states criminalizing the act of leaving one state to go to another, or helping someone to leave one state to go to another?
Yeah. Well, of course, there's an ignominious history in this country of doing that when it came to interracial marriage. There were states, including Virginia, as recently as in the 1960s, that not only made it illegal to get a marriage in another state that you couldn't get in your own state, actually criminalized doing so. That's what happened to Mildred and Richard Loving when the Supreme Court used their case to say that bans on interracial marriage could not stand. I think this is, law review articles are already being written. This is the next wave of very complicated issues, these interjurisdictional conflicts. Justice Kavanaugh, in his concurrence, said there is a constitutional right to travel, a right to move between states without interference. And so one might think that the simplest, the easiest question is, could a woman temporarily leave her state to get an abortion and then return? I think the best answer to that is yes. Could states say that, could a state say that a person like that has committed a criminal act? Remains to be seen. There may be states that will try to legislate and make that argument. And I think inevitably these cases will be tested in court. More difficult cases might involve, for example, the mailing of medical abortion supplies, medication abortion supplies across state lines. The United States Attorney General has already said that such drugs are considered safe and effective by the FDA, and that preempts the ability of states to regulate them. Those are only two, I think, of the, in an age of where most abortions are actually medication, not surgical, in an era of telemedicine, in an era where you will see third parties wanting to provide assistance to women in seeking abortions. I think all of these questions remain relatively open. And the main thing we can say with certainty is that some states will probably try to pass laws affecting them, and those laws will be tested in court. But I think the dissenting justices in Dobbs make the point that this provides a further example that the outcome in Dobbs doesn't settle a social controversy. It simply adds new dimensions to it.
What about, anybody want to just comment on the, I guess that there's several questions that suggest that this is, it just feels like a policy move by the court. Some deem that as a bad thing. Some deem it as like it's inherently a matter of policy and it's appropriate to be returning this to the legislative process. But I guess there are several questions that sort of say, isn't this just kind of the result of a partisan shift of the court?
I might comment on that. I mean, in the first place, I think that one of the difficulties with the Supreme Court maintaining its legitimacy today in the eyes of the population is the fact that now the controversial decisions, including this one and others, including the gun case, including a religion case decided yesterday as well, tend to be decided on a 6-3 vote that is not only, you might say, informed by judicial ideology or philosophy, but also mirrors the political party affiliation of the president who appointed the justice. So we have a 6-3 decision decided by judges appointed by Republicans with 3 dissenters appointed by Democrats. That was not the case really throughout my entire period of teaching law until recently. You had justices appointed by Republicans who tended toward the so-called liberal wing and vice versa. In Roe versus Wade, Justice White, for example, was a dissenter appointed by Justice Kennedy. So that, I think, is a troubling pattern in terms of the Supreme Court's ability to maintain its institutional integrity as much as it might try to do so. I think the other difficulty in terms of, I think if you just look at Dobbs in isolation, I think it is reasonable to maintain that the decision can be justified if one believes that political branches should decide issues unless and to the extent that the Constitution more or less explicitly protects a constitutional right. Otherwise, let democracy in the sense of popular governance prevail. The difficulty with that is the gun case, for example, is the religion case from yesterday, where a state school district attempted to prevent a football coach from praying on the football field in a circumstance that some alleged was coercive of his players. So the problem here, I think, is if you had a consistent pattern of deference to the political process, that might be more defensible than when you're deciding other controversial cases in a way that is not deferential at all.
You know, was Roe versus Wade thinly reasoned, basically a sort of political, almost legislative judgment by 7 justices, albeit a politically diverse group? Yes, when I taught Roe and constitutional law this spring, even my students who were strong supporters of reproductive choice had to acknowledge the reasoning of Roe is very thin. And so that made it vulnerable. You know, one political decision in Roe is swept aside by another political decision in Dobbs. The difference, though, I think, is at least I am a subscriber to, you know, a sort of theory of constitutional interpretation that says constitutional law interacts with society and culture and becomes embedded in society and culture. And to me, that's the difference, that you can't say this was just error correction or this was just one political decision substituting for another, when you have had the kind of social acceptance and social reliance on the decision, when it's become embedded in our society and culture for almost 50 years. That makes up for the fact that it may have been originally thinly reasoned. It has now become, I think, embedded in our law, reaffirmed by the court. That's what, to my mind, the major error of Dobbs was, not accepting that idea.
Just to briefly add to that, I mean, I think that even accepting some portion of what Professor Sanders just said, abortion has not been settled in terms of the political divide in any way comparable, in my view, to an issue like same-sex marriage, where on same-sex marriage, you have now majority support, even among Republicans, for the proposition that marriage should not be denied to those who are not traditional opposite-sex couples. On abortion, you know, you see all these statistics and they're subject to manipulation. There's a majority that disapproves of Dobbs. At the same time, there are statistical surveys suggesting that a majority of the population supports restrictions on abortion in the 2nd trimester. And in fact, most abortions take place very early in pregnancy. There was a report out from the Indiana state government, if I'm getting it correctly here, that fewer than 1% of the abortions in Indiana in the year 2020 happened after 14 weeks of pregnancy. So that, you know, 2nd trimester abortions are rare. Most abortions take place early in pregnancy, so that one could imagine if we're talking about general popular opinion, that there could be a compromise view that would not be all the way to vibrate. Something like Chief Justice Roberts, in fact, seemed to be suggesting in his concurrence in Dobbs. So I'm not entirely sure at the level of cultural acceptance that we have had that for Roe versus Wade, even after Casey. But there certainly is a 50-year-old precedent that is being overturned.
And I don't want to belabor the issue, but I just checked the Gallup polling. So if you add up the number of people who say they want abortion to be legal under any circumstances or legal under certain circumstances, it's 85% of the public. Only 13% say they want it to be illegal in all circumstances. Now, again, that's different than saying everybody wants it to be a constitutional right, but I have always taught, when I teach constitutional law, that the law we had, where the restrictions were possible and the undue burden test did allow for states to dissuade women and abortion could be outlawed entirely during the 3rd semester, the regime we had basically is what most Americans wanted.
I'm just going to jump in to say, in the history of spirit and tradition, in the spirit of history and tradition, tongue in cheek, we also have to consider here, when we're looking at political issues and composition of the Supreme Court, that the nomination and confirmation processes of at least 2 of these justices was anything but normal due to Mitch McConnell's manipulation of longstanding rules and protocols. And if these rules and protocols had been followed, the composition of the Supreme Court would have looked different, because Merrick Garland would not be in the Department of Justice. He would be on the Supreme Court, most likely.
You're muted.
Yes, I saw. Picking up on a question, that was posed here and that I've seen a lot, which is, what during the confirmation hearings, several of those justices assured questioners that they considered Roe's settled precedent. Should there be consequences to that? And more generally, what role, if any, can confirmation hearings play, or should they play, in sort of grappling with these questions and the approach to precedent?
Jody or Dan may take a different view. I quibble with that. I think if you read and parse very carefully what nominees like Justice Gorsuch and Justice Kavanaugh said, they just stated facts. Roe is a precedent. Casey reaffirmed Roe. Precedents are entitled to respect. But we also know that Supreme Court majorities overrule settled precedents sometimes. So I think, did they seek to mislead naive, less informed people who would read into what they said a guarantee that, Roe was going to be okay, like Senator Collins apparently did? Yes, I think they did. But I don't think there is anything, if you understand that, one of the jobs of Supreme Court justices sometimes is to overrule precedents. I don't believe there's anything that they said in their hearings that wasn't simply just literally true. Now, people may have wanted to read into what they said more of a reassurance, but I don't think they ever explicitly said. They said Roe's a precedent. Precedents are entitled to respect. They never said, that we won't revisit Roe.
Picking up then on the earlier point, which is that when you poll the public, it seems most people polls suggest land kind of similar to the old rules, that is widespread availability in the first trimester and then greater restrictions after that. If states pass much more restrictive laws, or the trigger laws that are on the books, that already went back to a highly criminalized structure, what do you think the political consequences might be of that?
Well, presumably that will play out over time. I mean, basically, Indiana will be a good case in point. I mean, the legislative leaders have promised full hearings, respectful consideration of different points of view. We'll see what happens in terms of who participates in those hearings, the arguments that are made, the result that emerges from Indiana, which is a conservative state, but arguably less conservative than some of the other states that have already acted. So I think the question really will depend upon longer term political movements and responses to what the various states do, and I think so. So I guess I would say that remains to be seen. Others may have different reactions.
Anyone else want to weigh in? All right, well, then we have a question that's specifically on how students here can get involved if they want to have an impact on those decisions and policy questions. And then a different question, which is what Maurer will do for its students who might need abortion services if the Indiana legislature were to pass very restrictive rules. Christy, you're muted.
Goodness, how do we keep forgetting such things? I didn't introduce myself when I introduced the webinar. My name is Christiana Ochoa. I'm currently the Executive Associate Dean, but as many of you on this webinar will know, our current Dean is stepping away as of Friday, and I will become the Interim Dean at that point. So I will field the question about what Maurer will do to support our students. I started the conversation today by referencing or by referring our students to our Office of Student Affairs. Our Office of Student Affairs has counseling services available and can direct you to counseling services. And in addition to that, our Student Affairs Office has a long tradition of providing emergency assistance, financial assistance to our students in need. So I would recommend to our students that they remain in close contact with our Office of Student Affairs, as we have a long tradition of supporting all of our students.
And then more generally, what can students or anyone who wants to be involved on this issue on whatever side, what steps would you suggest people take?
Yeah, so there, the most important thing is for everyone to just remember that a legal degree is a powerful degree. knowledge of the law and the ability to engage with it and use it as a tool is incredibly powerful to all of us, as we see by this opinion and others that we might support or object to. And so for those of you who are engaged in this issue, I recommend that you, we know that this is going to become a state-based issue, at least for the foreseeable future, become involved in your state electoral process. Engage in voter registration petitions, be sure to vote and encourage others to vote as you see fit, and work with non-governmental organizations, work with women who are with people who are directly in need of healthcare of all sorts. Different people are going to have different methods of wanting to use their legal degrees and their personal energies in the most effective way possible for them, that also gives them energy rather than depleting them. And so I would recommend to each person on this call to be engaged in ways that work best for them.
Any other panelists want to weigh in just on that question of sort of how to get involved or what to do?
I'll give what might just be an unconventional answer, and that is, also think about the federal level. Now, that's a double-edged sword. Arguably, if it were not for the filibuster, with Democrats controlling both the Congress and the president, we might have the possibility of a nationwide statute, a federal statute that would do the same thing that Roe did. That's not possible because of the Senate filibuster. Although, on the other hand, if control of the Senate and the House should change parties, then the filibuster might be the only thing standing in the way of a proposed federal law to ban abortion. But I certainly agree with Dean Widiss that this issue is going to be primarily fought over at the state level, but there may still be a role for the federal government to play as well.
I might add that there could be at least in a world in which Congress chooses to so act, a compromise federal proposal. In fact, I have an op-ed coming out in Politico, hopefully sometime later this week, that argues that such an approach would be potentially desirable in terms of attempting to bring the nation to some type of common purpose on this issue. The odds of that may not be great, given the deep divides that we have in Congress as elsewhere. But I think Congress, as Professor Sanders suggests, if the political will were there, it could move all the way to a federal ban on abortion. It could have a compromise approach of some sort. If it attempts simply to codify abortion rights, there could be some issues in terms of congressional power, in terms of Congress's power to define constitutional rights. In other words, it might be a little bit trickier if it is simply a codification of rights without any regulatory component, which might make it more difficult to justify under Congress's power to regulate interstate commerce, and might rest instead on Congress's power under Section 5 of the 14th Amendment to enforce constitutional rights. The 14th Amendment power has been read somewhat narrowly by the Supreme Court in recent decades. So that might or might not survive if it's purely a codification of Roe or something like it.
I am so sorry when we come to the end of an hour, when we have such terrific discussions such as this one. It falls on me to wrap up our discussion. We are at the top of the hour and our attendance is starting to fall off. But before that happens, I placed in the chat, but I definitely want to flag for all of those who have joined us today that the law school, the Maurer School of Law, intends to make this a regular practice of helping us all understand the decisions that are coming down from the court. This is a very different court than the one we had just a few years ago, and the decisions that are coming down will require a different kind of engagement, and in order for all of our community to better understand the new context in which we find ourselves. So we hope you will join us for those future events, and I definitely want to take the opportunity to thank all of my colleagues for this incredibly terrific discussion. There are a lot of comments in the Q&A, just thanking all of you for your time and your effort and your energy and your intelligence and your assistance to their ability to understand. this opinion. And so thank you all very, very much. Thanks for joining us.